Welcome to Mental Disabilities and the Criminal Justice System. I'm Elizabeth Kelley. I'm a criminal defense lawyer, and I specialize in representing people with mental disabilities. On this podcast, we provide information and hope to people with mental disabilities caught up in the criminal justice system, as well as to their families. This episode is part of a series where we will talk with various authors who wrote chapters in the upcoming second edition of my book, Representing People with Mental Disabilities, A Practical Guide for Criminal Defense Lawyers, published by the American Bar Association. In this episode, I will be talking with Judge Jay Blitzman. Judge Blitzman served as the first justice of the Massachusetts Middlesex Juvenile Court. Before his judicial appointment, he was a public defender who was the co-founder and first director of the Roxbury Youth Advocacy Project, which was an interdisciplinary public defenders unit that was the template for the creation of the statewide Massachusetts Youth Advocacy Division. Judge Blitzman is a prolific writer, and in that spirit, he wrote our chapter on youthful offenders. Judge Blitzman, if someone were reading it out of Representing People with Mental Disabilities, A Practical Guide for Criminal Defense Lawyers, and taking a look at the table of contents and saw that there was a chapter on youthful offenders, and they thought, what on earth is a chapter like this doing in a book titled Representing People with Mental Disabilities? What would your response be?
That's a great question. A question you actually pose yourself in the very provocative introduction to my chapter. What is a chapter about youthful offenders doing in a book about representing people with mental disabilities? You answered the question, and I agree with you in large part. First, to the degree that mental disabilities are brain-based and the adolescent brain is still developing, thus lacking maturity when it comes to issues like self-regulation and long-term thinking, it is vital that criminal defense lawyers are aware of the particular characteristics of this population. And second, a disproportionately high number of youth involved in the criminal legal system have behavioral issues and have suffered trauma. By the way, as regards trauma is sort of a continuum. We're talking about everything. When we're talking about behavioral health, we should also be talking, obviously, about adverse child experiences, trauma, and then complex trauma, all of which delay normative maturation and can even elongate what we've learned through brain imaging about brain development and adolescent development, which can go on until age 25. The National Institute of Health data indicates that as many as 75% of the children and youth we see in our court system have diagnosable mental health issues, many of which would be qualified for a DSM-5 diagnosis. Another important issue in this very complicated landscape is the reality that many young people suffer from various disabilities. Educational disability. Many of the youth that we see in court systems have individual education plans and or a 504 accommodation plan. And sadly, a very, very high percentage are also dually involved in our care and protection, our so-called family regulatory system. So it's a really complicated landscape. And understanding this means really taking a deep dive into behavioral health in adolescence and trying to educate ourselves, if we're dealing with this population, about the social and cultural context that young people live in, as well as understanding the developmental landmarks that we're now becoming aware of given brain development. This is part of the landscape.
Judge Blitzman, during your response to that question, you used terms like children, youth, young people. You did not use the term juvenile. And indeed, this chapter is titled Youthful Offenders. Why has the term juveniles found disfavor in some circles in recent?
Well, I think it's understandably being viewed more and more as a way to be dismissive of children, to sort of infantilize them, to objectify them. And I think it's increasingly becoming part of the canon that using that phrase is inconsistent with a more strength-based attitude or model of supporting positive youth development. I'll give an example. The National Juvenile Defender Center has renamed itself to be called the Galt Center. We think about the word juvenile. Think about how we use that word in everyday conversation. If you call one of your friends juvenile, it's a pejorative. It's a negative way at looking at children. I think moving in a more strength-based, positive youth development orientation makes a lot of sense. I am a member of this group that tries to check myself every time I use that word juvenile.
Interesting, interesting. Well, your use of the term Galt Center leads us into the very rich area of how do courts for youthful offenders differ from so-called adult courts. Let's start with the term Galt. Who was Galt? What was the Galt decision?
The Galt decision, let's use that phrase, the oft abused phrase, the seminal case in juvenile law. A Supreme Court opinion decided in 1967 in which, for the first time, an indigent youth was accorded the right to counsel. Jerry Galt was 15 years old. He was arrested in Maricopa County, Arizona, allegedly for making telephone calls of the so-called indecent adolescent variety. But it's unclear, looking back through the fog of time, what was actually said. Because in 1964, when he was actually arrested, there was no such thing as a trial for an adolescent. The adversarial model was not part of the youthful offender world. In fact, the medical model was the paradigm. Of course, the sad reality is that in 1964, when Galt was arrested, only 1/3 of the juvenile court judges sitting across the country had actually gone to law school. Some actually had not even graduated law school. There were no specialized court clinics. So expertise, the touchstone of the venture of the specialized court, was not even present. But Galt is really, really important in terms of elevating the importance of really understanding that the only thing that's really therapeutic for a young person is fairness, fundamental fairness, due process. That means giving voice to that individual so that he or she is really enfranchised and is part of the process. Galt received a 6-year indeterminate sentence to the Arizona State Industrial School for unspecified conduct. An adult charged with comparable conduct would have received as a first-time offender perhaps a $30 fine or a maximum of 30-day jail sentence, and they would have had a right to an attorney. Justice Fortas, writing for the majority in the Galt opinion, notes that as regards this issue of treatment and rehabilitation versus due process, actually representing somebody and giving them voice, it was a dubious way to go. He wrote that as far as the adolescent is concerned, a more therapeutic alternative may well be the essentials of fundamental fairness, which is what we lawyers, use as due process.
So, in light of that, what specific legal standards or protections exist for youthful offenders, and in particular, youthful offenders with mental disabilities?
Well, I think it's been a struggle to move away from this notion that we'll have specialized procedures for young people, which essentially also include not giving them due process. So hopefully, and I think to some degree and a large degree, we have moved away from the pre-Galt era. And many modern juvenile courts actually have much greater due process protections. But make no mistake, Galt is not the functional equivalent of Gideon, the 1963 criminal case, because the scope of due process rights for young people as a matter of federal constitutional law still only applies at the bench trial. Each state designs the contours of its own juvenile court system. That includes right to counsel at arraignment, detention, whether or not there's a jury trial, issues of transferring serious allegations of misconduct to criminal superior court. So I've written about this frequently. As far as I'm concerned, Galt's promise remains aspirational. That said, a good juvenile court with good advocacy means really understanding the social, the ecological context in which young people live and the larger frames and systems that affect them. That means educating yourself if you're representing a young person, not only about, in addition to understanding the legal issues, the elements, and what degree of mens rea is required, it means also educating yourself about their educational history, their mental health history, any family involvement in the dependency or child and family regulatory system, and a variety of other factors. I just want to share really, really quickly to give you sort of this context. My sort of origin story in representing young people dates to representing a young woman in the Boston Juvenile Court when I was a third-year law school student. My clinical supervisor, for some reason, was not with me that day, but he assured me, Jay, don't worry, you'll go to court. This is a first-time offender. She was charged with common night walking, a euphemism for prostitution. She's an adult, I was told, and she's going to get personal. Don't worry about it. Well, it turned out that this young person had lied about her age. She, in fact, was a person within the jurisdiction of the juvenile court, and she and her family were involved in the alphabet soup of state agencies and multiple agency involvement. She had a history of suicidal ideation. She had failed to graduate. She was a runaway. She was being sexually trafficked. And I realized, oh my word, if I'm going to effectively represent this client, I really had to get busy. I had to become at least a generalist in many, many areas so I could intelligently communicate with her, try to develop a relationship with her, try to reach out to whatever family members I could locate to get what Brian Stevenson calls as getting proximate, really trying to understand the world so I could really create a trusting relationship with her. Later, when I was able to create the Roxbury Youth Advocacy Project with others, that experience really had impressed me so much that we made a conscious effort to develop an interdisciplinary legal public defenders unit. We had social workers on staff, we had community outreach, we even had a clinical psychologist so that we could effectively represent our client, and a multidisciplinary, holistic approach to legal advocacy, trying to address issues that she was involved in whatever court process she had to confront. I became really fascinated by working in that space.
That's a fascinating origin story. I want to go back to a point that you raised a few moments ago about how you develop communication strategies with this girl or this young woman. Tell us a little bit more about some of the strategies that you employed, and in turn, tell us a bit more about your years on the bench and some particularly effective communication strategies that you observed other criminal defense lawyers use.
All right. Well, so I begin with what I did because I was a public defender for 20 years before I became a judge for almost 24. So I learned early on that in order to effectively communicate with my client, I really had to establish a degree of trust. Relationship, especially with a client like this who had been profoundly traumatized and effectively abandoned by responsible adults in her life and had constantly felt betrayed by various systems of state intervention. That meant visiting regularly. This particular client was in detention, but for clients who are not in detention, this means or meant being willing to interview them in an environment where they felt comfortable, not in a legal office. That could mean meeting in a community-based location. It could mean meeting at home. I come back to that Stevenson phrase about getting proximate because I think it's important. I remember back in the day when I was visiting clients to show you how the culture was. When I would show up at a detention center to visit a client, people there were surprised. And this relates, by the way, to your question about using the word youth versus juvenile. We've always been, unfortunately, as regards young people, very, very judgmental. One thing as a judge, I had a little sign on my bench which said, a judge should not be judgmental. And I think we're too quick to categorize and make assumptions about people generally. And I think this leads to this sort of noblesse oblige attitude about young people. We'll decide what's in their best interest. That's a phrase, by the way, that I've always had trouble with. To me, what's in a child's best interest, this connects back to the Galt conversation, is due process, fairness, really making sure that somebody is heard. And I observed that as a judge, lawyers who went out of their way to make sure that their clients were zealously directed, lawyers who engaged in client-directed advocacy, who didn't speak in phrases, well, I think what's best for John is, or What's best for Susan is attorneys who understood the ethical obligation under the rules of professional responsibility to engage in client-directed advocacy without qualifying it. There's so many voices in every juvenile court session where people are opining about what they think is in a child's best interest. If everybody was doing that, then who really speaks for the young person? So when I would see an attorney do what I really believed was appropriate, maybe this is my own confirmation bias, I get a tingle. I think about it even now. I get a tingle in my spine. You know, the tingle was lawyer in the house, somebody who is really a champion of that client, treating that client like they would any other client, understanding the world that they inhabited. When I think about the attorneys who appeared in front of me in many years, the ones who really took that extra step, the ones who really cared about their clients, who really were able to humanize them, develop compelling narratives so that they were really heard.
How to respond to all that. I love your phrase, there's a lawyer in the house. And you raised a point very early in your response, which I could not agree more with, along the lines of taking time to form the relationship and the bond of trust. And one of the points that I try to get across with other lawyers, not only lawyers who are representing juveniles, but also lawyers who are representing people with mental disabilities, is this relationship takes time.
Exactly. Exactly. It should be the same with any client, ideally.
But with these clients, it takes
I
longer
agree.
for 1,000 different
A
reasons.
thousand different reasons. Again, the level of mistrust and skepticism, especially if you're a court appointed lawyer, that perception is based on the fact that they feel that they've been given second-handed justice. A lot of people who are court involved are very, very wary of our systems of state intervention, and justifiably so. This is related to the combination of factors that contribute to what we call the birth or cradle to prison pipeline. They or their families have been involved in various levels of state surveillance through child protection agencies, through police and schools, community surveillance. A lot of these young people are very, very wary. And to the degree that they've suffered adverse child experiences, to the degree that they've suffered, endured trauma, much, much, much exponentially more so. You know, I second your emotion regarding the time factor. You know, one thing I learned early on as a lawyer was I think about the case opening booklets that we had when I was a public defender and ones we use at the Youth Advocacy Project. We try to teach our attorneys you want to get releases of information as soon as you can, preferably on day one. You got to have access to whatever records are out there, any prior court evaluations, AP evaluations, educational records, mental health records, records from the Child Protection Agency. But I realized, wow, imagine how you would feel, how I would feel if the first time I met somebody would thrust like 8 releases of information in front of me and said, "Hi, please sign these."
You are absolutely
I
right.
would think,
You
whoa,
are absolutely right.
slow down. You move too fast. I know you don't want me to sing, but I'm ready to break into song. Slow down. You move too fast. That is important, but not at the first interview. The first interview, the first meeting, let's establish a relationship. Let's really build that relationship. A lot of people who end up in these kinds of situations, they've been let down so many, many times. So you've got to earn trust. You got to walk the walk. You know, you're probably familiar with the mantra, nothing about me without me.
Correct.
That's really, really important. Don't sell your client out. Don't be sharing information under the notion, well, because you think it's in their best interest. And that's why I've always been very, very wary regarding surrogate types of representation, whether it's in juvenile justice or the family regulatory system. Law guardian types of representation, guardian ad litem representations about what's in a child's best interest. Not if you're representing the client. That all relates to client-directed advocacy. And by the way, there's a virtual unanimity if you look at the literature regarding perceptions of youth who are involved in the court system. I'm sitting in my little home library. One of my favorite books is Reforming Juvenile Justice, a Developmental Approach. This was a study commissioned in 2013 by the Office of Juvenile Justice, Delinquency, and Prevention. And the studies as far back as then show that not only the appearance of fairness, but the actuality of fairness is essential. If our legal processes have any legitimacy, A young person has to believe that they were really heard, that there was a fair procedure, that justice wasn't done to them. They were truly, truly heard. A recent English study done last year confirms that, interviewing young people who have gone through the English system. So this is obviously something which I think is true for young people internationally. It's part of the reality of adolescent development. And understanding that, being attuned to that, understanding the responsibility you have and the damage you could do if you betray the trust, the sanctity of the attorney-client relationship, which should be treated as any other, cannot be understated if you, in fact, violate legally your ethical obligation to really give voice to your client.
That will have to be the last word, Judge Blitzman, but I want to thank you for spending time with us today. And more importantly, I want to thank you for the passion and the knowledge you brought into writing your chapter in my book on youthful offenders.
Well, I want to thank you, Elizabeth, for the opportunity to contribute in some small way. I think it's a good chapter. I just hope that the lessons and the things that we care about reflect shared values and that hopefully positively impacts the legal culture regarding representing young people. So thank you.
Here, here. Thanks again.